So the background is that the National Labor Relations Act applies to non-union employers. It was created to protect union organizing, but it applies to everybody. So if you're sitting in this room, the National Labor Relations Act applies to you. Section 7 prohibits employers from restrictions on employee concerted activity regarding working conditions. Now, there's no specific definition of what that is, and the NLRB is the body that's charged with saying what that means. The NLRB is a political body. The appointees are they're presidential appointees. So during the Obama administration, there were a number of people on the NLRB who were very interested in trying to protect unions and encourage or discourage employers from doing anything that might be considered to be impacting employee rights to unionize. So there was the standard for deciding whether an employee policy violated Section 7 was whether an employee could reasonably construe it as impacting concerted activity. Well, the board went way one direction, and their idea of whether it's reasonably construed that way was really meant, can anybody in any conceivable scenario, theoretical scenario, find that this impacted concerted activity? With the new administration, the NLRB totally changed. There are new presidential appointees, and they basically rescinded that standard and have now come up with what, in my view, is a much more reasonable standard. The case involved Boeing. Boeing had a rule, you can't bring cameras into the workplace, that includes cell phones, because we don't want you taking pictures of our planes, our manufacturing processes, all those types of things. The administrative law judge, based on the old rules, basically said that was improper. It was a violation of the NLRA. The board, the NLRB, the new board, basically said that's not true. They specifically overruled the prior decision and said that the burden now is to show a potential impact, that a reasonable employee, it's not an employee who has a reasonable concern, it's a reasonable employee. So you're limiting it, you can't go into these haywire, way off base speculations. What would a reasonable employee, how would they interpret this policy? And if they interpret it in such a way that it may impact Section 7 rights, does the employer have a legitimate business justification for it, which had never been part of the standard before? And so they found that Boeing policy was perfectly acceptable. Now, how does this affect you? Current application to employer policies, and this is where the rubber hits the road. So workplace stability standards. It's permissible if you have policies directed at employee conduct toward other employees. In other words, you can't fight with them, you can't abuse them, things like that. It's permissible when it's directed at disruptive behavior that impacts the workplace. That makes sense. It's problematic when it's directed at disparagement or criticism of the employer itself, because that presumably is someone complaining about their working conditions, which is protected by the NLRA. Confidentiality of employer information. It's permissible when directed at trade secrets, employer property. It's problematic when it's directed at information the employee gets as a result of their employment, because in order to complain about your working conditions, you would have to use information obtained during the course of your employment. So that creates a challenge. And it's problematic when it's directed at use of the employer name. So in other words, you can't prohibit somebody from ever talking badly about you. That's a problem, because the employee has a right under the NLRA to talk about their workplace conditions. Employee interactions with media and social media. It's permissible when you restrict employees from talking on behalf of your company. It is not permissible for you to prohibit your employees from talking about your company at all. If they're not talking on behalf of the company and they're just talking, that again could impact their right for concerted activity to talk about their working conditions, which is protected by the NLRA. Personal conduct standards. It's okay when it's directed at disloyalty or nepotism or things like that. It's problematic when it's addressed at things like conduct that's contrary to the best interests of the employer. Because obviously anytime an employee complains about their working conditions, it's contrary to the best interests of the employer. It's problematic when you're prohibiting cell phone or email usage during non-work time. So if you tell an employee, hey, you can't bring your cell phone in here, you can never talk on the phone during your breaks or your meal periods, that's a problem, because who knows, they might be doing some sort of talking about their working conditions. So you can't do that. And on your time, yes. On their time, no.